The Supreme Court just undid the electric vehicle mandate. The Supreme Court's recent ruling on the Chevron deference could affect federal regulations of everything from power plant emissions to electric vehicles to transmission lines. And this could be pretty good news. This changes the mandate for the Green New Deal and electric vehicle mandates. This is a win for consumers to choose their own independence machines or vehicles. I'm going to start calling your vehicle an independence machine. Now courts will have more to say in interpreting the rules on everything from EPA's latest effort to curb power plant emissions to the Federal Energy Regulation Commission's orders. This is going to take some time to undo. However, Senator Ted Cruz explains what this is all about. The Chevron decision created something that is called the Chevron deference. Now, what is a Chevron deference? It's important to know that. It was a doctrine that was said that the courts will defer to federal agencies on rules and regulations, so as long as that rule and regulations is, in quote, reasonable, Cruz said. What it did is give enormous powers to unelected bureaucrats and Chevron. And you can trace in every single direct line the rise of the administrative state, the rise of unelected bureaucrats issuing rules that are incredibly costly to you, the American citizen, incredibly harmful to the American people, and you can trace that rise to the Chevron doctrine, Cruz stated. The courts would refer to the ruling in handling unelected bureaucrats enormous amounts of power to regulate American lives. The Supreme Court last week overruled Chevron. What that means now is that Congress, its elected members that you elect, will have to make the policy decisions that impact American people, not the armies of bureaucrats who have no democratic accountability, who are completely unelected but appointed. Now, elected officials don't always make the best decisions, we know that, but it's better than someone saying, here's the new rules, and too bad for you. Well, some of those initial rollbacks include the EPA's role in cutting carbon emissions from power plants, as well as regulations to encourage electric vehicles. There are wide-reaching implications for oil and gas industries because it will make it more difficult for federal agencies to regulate the industry based on their interpretation of ambiguous laws. EV regulations are facing massive changes or removal following this rule, and these regulations could face challenges that might reach the Supreme Court as soon as this fall. And the EPA, or the Environmental Protection Agency, power plant regulations and broader climate regulations also stand on shaky ground. This shift could significantly impact the push for green energy solutions in the United States. Whether you like them or not, they need to be passed by Congress, not by some appointed official. The ruling adds to the already heated debates about whether the EPA has the authority to regulate emissions from vehicles at all. And the Biden administration's strict tailpipe emissions standard has become vulnerable. They have had success watering down the EPA tailpipe emission rules in the past, and some of their challenges are still pending and could be subject to the Supreme Court Chevron decision. David Pettit, senior attorney for climate and energy with the National Resources Defense Council, predicted that critics would use this Chevron decision to launch new attacks on vehicle rules that regulate greenhouse gases. This gives you a chance, actually, to talk to your elected officials and tell them what you want, one way or the other. At least they get to hear what you have to say, and they know that your vote counts. A 26-state coalition filed a legal challenge to the U.S. Sixth Circuit Court of Appeals against the National Highway Traffic Safety Administration, or NHTSA, to block the agency's new fuel economy requirements for passenger cars and light trucks, which the agency had finalized on June 7th. The rule will require automakers to adhere to the industry-wide fleet average approximately 50.4 miles per gallon for passenger cars and light trucks by 2031, a move that critics say would force car companies to drastically increase the share of their fleets to electric vehicles, and none of the manufacturers meet that 34.5 miles to the gallon that we're at right now. In turn, this would negatively impact consumer pocketbooks and American energy independence, and basically it's going to cost you more for vehicles and you'll be forced to go to electric cars. Hence, we want to see what the Supreme Court says on this one. Now, in addition, this is a win for the automotive aftermarket. The High Court has provided increased regulatory certainty to small automotive parts businesses around the country, including the specialty automotive aftermarket companies that have been adversely impacted by the federal regulations overreach and would put a lot of small companies out of business, which would affect labor and, of course, potentially your job. Could this be the end of the electric vehicle mandate? Well, the Supreme Court ruling certainly opens the doors for the mandate to be dropped. We are not there yet. We will keep you posted as this unfolds. Subscribe and follow us so you don't miss any updates. If you like this video, give it a like and subscribe for more videos like this one. If you have any questions or comments, I'll be more than happy to answer. You can support me by buying me a cup of coffee. The link is in the description, plus all the links for our website, social media, my book, and our podcast. I'm Lauren Fix. Thank you so much for watching.